We're here to make the complex simple and the confusing clear. Let's take a look at the Judicial Branch. More specifically, let's look at the United States Supreme Court. Presented by Citizen U. We are, after all, a nation of laws, not men. But the Constitution is what the judges say it is. The founders thought the Supreme Court would be the least dangerous branch. Doesn't sound least dangerous to me. Let's look at our federal court system and the three layers. The first layer would be the district courts. Federal district courts are our trial courts with original jurisdiction. The second level is made up of the federal appellate courts, appellate jurisdiction, not determining guilt or innocence, but reviewing district court decisions. And finally, the United States Supreme Court, also with appellate jurisdiction. They have the last word on constitutional law. Let's look at the United States Supreme Court and its members. What happens when one justice leaves? Federal judges are appointed by the President. Oftentimes, the President has what's called a litmus test. Federal judges should agree with the President's ideological positions. Federal judges are then confirmed by the Senate after being appointed by the President. On the Supreme Court today, there are voting blocs, conservatives and liberals. There are thousands of cases appealed to the Supreme Court each year. How do they go about deciding which cases to hear? Especially when we consider each year they only listen to about 80 cases. They decide those 80 by what's called a rule of 4. When 4 of the 9 justices agree to hear a case, that case is granted a writ of certiorari, or in other words, that case will be heard by the United States Supreme Court. How do they decide? First, the Supreme Court reviews the legal briefs. These would be the proceedings from the earlier courts, primarily district court transcripts. Then, each side in a respective case has usually 30 minutes of oral arguments before the 9 justices. The justices then read amicus briefs. These are friends of the court who really are trying to lobby the justices for one particular decision or another. Finally, the Supreme Court holds a private conference. Here the justices debate each side and weigh the legal arguments, followed by a simple vote. In the United States Supreme Court, a simple majority wins. Then the court writes their opinions. The opinions are the rationale of the court. The majority opinion is the rationale of the majority decision. A concurring opinion sides with the majority, but for different reasons. A dissenting opinion would be written by those justices who disagree with the majority. A per curiam, usually a 9-0 decision, goes unsigned. Jurisprudence is a word that describes how judges make their decisions. Well, how do they decide? Especially when the law isn't clear. Conservatives favor a jurisprudence of original intent, sometimes called judicial restraint. Here, conservative judges try to hold their opinions strictly in terms of what the law says. Liberals talk more about a living constitution, that our Constitution and its laws evolve over time. This is called judicial activism. Oftentimes, activists are accused of using bias, their own personal experiences, to decide a case. Without a doubt, however, both conservatives and liberals try to hold their opinions to precedent. How has the court decided in previous cases? This is called stare decisis. Let's look at some of the historic landmark cases. Marbury v. Madison established judicial review. McCulloch v. Maryland established the supremacy of the federal government. Gitlow versus New York is selective incorporation of the First Amendment speech clause. Brown v. Board of Education, in historic civil rights case, the Supreme Court integrated the schools. Separate is no longer equal. Baker v. Carr, the Supreme Court got involved in the political thicket. One man, one vote. Roe v. Wade, the Supreme Court recognized privacy as a fundamental right. Buckley v. Vallejo, the Supreme Court recognized that campaign finance is a First Amendment freedom. Money is protected by free speech. Citizens United versus the FEC, a more recent case in which the United States Supreme Court recognized corporations as having the First Amendment privilege to give money to independent expenditure groups, super PACs, 527s. We're here to make the complex simple and the confusing clear. Today we're looking at the judicial branch, the United States Supreme Court. Is justice blind? Presented by Citizen U.